Good afternoon and welcome to today's webcast, Preparing for and Conducting an Effective Mediation, with speakers Andy Dorman and David Hudson. My name is Kimberly Labounty and I will be facilitating today's broadcast. Before we begin, I would like to review a few important notes and tips to help make today's broadcast a success. First, today's slides are available for you for download. Simply click on the Resources tab along the left and click to download. Also available are the bios of today's presenters. Andy and David will be answering questions throughout the webinar. If you have a question for them, simply type it in the question box available along the lower left side of your screen. Finally, at the close of the webinar, an evaluation will appear on your screen. You must complete this evaluation in order to receive credit for today's webinar. Should you leave early or close out of your screen before the webinar ends, you will not see this window and will not be able to receive credit. We will also be checking attendance throughout the broadcast, so please be alert. Preparing for and conducting an effective mediation is presented by Reminger, a Midwest firm with offices strategically placed throughout Ohio, Indiana, and Kentucky. Attorneys cover 30 practice areas, and many are licensed in additional states as well. Our first presenter is Andy Dorman. Andy is an accomplished litigator licensed in Ohio and Kentucky. Practicing out of the firm's Cleveland office, he is the chair of Reminger's Professional Liability and Financial Services Professional Liability Practices Group. Our second presenter is David Hudson. David handles litigated claims for clients in state and federal courts in Ohio, Indiana, and Michigan. His practice is focused on such areas as professional liability claims, employment law claims, directors' and officers' liability, and securities litigation. Andy will begin today's presentation. Welcome, Andy.
Thank you, Kim, and good afternoon, everyone. I'm speaking to you from sunny Cleveland, Ohio. A couple of quick introductory comments before we get to the materials. David and I are very excited to be presenting this webinar, which is going to be the first of a series of webinars sponsored by the Alta Pro Lawyers Risk Purchasing Group, which is a program administered by Alta Pro, which provides professional liability, insurance, and risk management services to lawyers in the Midwest since 2004. Everything we say here obviously is our opinions and is not legal advice. And with that, let's get to the first slide. Today's topic is preparing for and conducting an effective mediation. Looking at the list of attendees, all of you are lawyers, or the vast majority of you are, so I'm going on the assumption that you have participated in a mediation, but that could be an incorrect assumption. So some of these things that we'll talk about today may be things that some of you already know, and for that we apologize, but we hope to provide maybe a new slant or ideas going into a mediation. Some of you are plaintiffs' lawyers, I'm sure. Some of you are defense lawyers, and some of you, I'm sure, are general practitioners. And for all we know, some of you may be mediators that are on the line with us here today. So why mediate? The old adage that we've heard over the years is how many cases actually go to trial. I think you've all seen this slide before, is less than 10%. I've been practicing law now for over 25 years, and I can say that that's a true statistic. Now, that doesn't necessarily mean that 90% of the cases are settling and are going to mediation, because as we know, there's many different directions a civil case can go from when it's filed, which could be a dismissal. For whatever reason, maybe because it was a forced dismissal with a pending motion, or maybe it was the wrong party and the plaintiff's counsel did the right thing and dismissed the party that didn't belong in the suit. But certainly, a lot of the cases that don't go to trial are resolved, and I would venture to guess that of those cases that are resolve at a mediation. Monopoly guy. What percentage of judgments go uncollected? This was a stat that even I found surprising, is that's a very large amount, percentage-wise, of judgments that go uncollected. And I do mostly defense work at Reminger. I don't do a lot of plaintiffs' work, but we all know that a judgment is a judgment, and it doesn't mean anything until it's reduced to cash. So, percentage, these are statistics from reliable sources that we did in putting this PowerPoint presentation together. Why mediate? If you're a plaintiff's attorney, why not, right? You're going to walk into a conference room and the defendants are going to be offering you and your client money. It may not be the amount of money you were looking for, but it's always a good thing to be have your case taken seriously, and as long as the offers that are being made are fair offers and are reasonable for what the value of the case is, there's really no downside. Plus, you're talking about ending the case sooner than later, as opposed to litigating it for, depending on what county you're in. If you're in Cuyahoga County here in Cleveland, it could be anywhere up to close to 2 years. But certainly I think the low end of it, in the states that we practice in, you're looking at least a year, and probably an appeal after that if there's legal issues. So the reasons to mediate are certainty, cash resolution, and ending the dispute on behalf of your client. It's also good for defendants, believe it or not, and their counsel, because if the case is being evaluated fairly, then you're only offering money because you recognize that you have weaknesses in the case, and the carrier recognizes if there's an insurance carrier involved, that it has weaknesses in the case, and it brings it to an end earlier than later, as opposed to litigating it for 2 years, when in the end you're probably going to end up in a conference room mediating the dispute at some point in time anyway. David?
Yeah, and we'll pick up from the why mediate issue, and that goes to a key issue of, are you court-ordered versus mediating by choice? And those things matter sometimes, but as we go through this slide, the key point from our perspective, I think, is that regardless of whether the court is ordering you to be there or whether you're electing to mediate by choice, the preparation points and the decision-making that we're talking about today should apply equally across the board. And the timing of mediation is the first consideration that we're looking at with this slide. And this hopefully will give you a little laugh with the cartoon. And, oftentimes I think a lot of parties either are not familiar with mediation, and that may be true for some of the folks on the phone, or haven't been through the process, or just fail to consider it, meaning your clients don't know anything about it. They're upset about the dispute, and they want to proceed to have the merits of their claim heard, and this really never crosses their mind. And by the time it does, sometimes, as seen in this photo, it can be towards the end of the dispute and perceived to be too late. What I would say is, in that decision-making tree of deciding whether to mediate, it's never too late, frankly. And the question really is, how early can you mediate sometimes? And, we mediate a lot of disputes pre-suit before the claim is ever filed, and sometimes within, I just closed a really large claim, and we mediated it within 30 days of the incident. And so the questions that we're asking, both with carriers and our clients, is do we know and do we have enough information? Have we investigated fully our defenses? Do we understand what they are, and do we understand what the damages picture looks like? And and then we take a look at the parties. What do we know about the plaintiffs and their family? And are they going to make good witnesses? Are they good people? Are they bad people? So on and so forth. And all of these things have to move quickly. But I would submit to you that the questions posed there, all of those things are very important in determining whether or not you're ready to mediate a claim. And the third item on this slide, in my opinion, may be one of the most important when there's insurance in play, and that is the exchange of information, especially if you're a plaintiff, needs to be full and complete and early, because if a carrier is involved, there's a lot of steps in that process. It has to get to the lawyer first, and then be passed through the lawyer to the carrier and to decision makers at the carrier who can decide on authority. And in our experience, that's a critical part in the process, and it does not move all that quickly. So if you're on the plaintiff's bar and you're listening to this, one of the keys in effectively mediating a claim, in our opinion, I think, is get the information out there, get a full disclosure out there, and get it out there early so that these folks have a chance to consider the merits of your claim and be prepared to put real money on the table and make mediation meaningful.
Thank you, David. So before I get to selecting the mediator, we really haven't talked about mediation as opposed to arbitration, as opposed to litigation. I'm assuming everybody on the phone knows the differences, but there may be some of you who don't. Mediation is a voluntary process. I know sometimes a court may order you to go to mediation, but once you're there, nobody can make you or your client accept a number you're not willing to accept. So it's important to understand that unlike arbitration and litigation, when a judge or an arbitration panel or a majority of the arbitrators make a decision, that is binding on the parties. A mediation is a voluntary process where you, in conjunction with the other defendant, if there's multiple defendants, decide as to how much a case is worth and what the terms of the settlement are going to be. So David talked about timing, and that is very critical, and it changes in every case. I've had some cases where they come in, whether it's pre-suit or in-suit, nothing's going to change in discovery, right? So if the facts are the facts, and if somebody has an injury and it's a legitimate injury and there's medical records to support it, what are we really going to engage in discovery for? Perhaps explore pre-existing issues or subsequent injuries, but after that, it's worth what it's worth. We believe, certainly at our firm, and I think a lot of our clients do too, which is a quick evaluation, and if we owe, we owe. It's just an issue of how much do we owe per case. One of the initial decisions that's made once it's decided to participate in a mediation is agreeing on the mediator. And this can be something that's easily decided with some cases, and in other circumstances, not so much. You want somebody who's going to be neutral. Even though that person doesn't have decision-making authority and can't decide anything, you and your client, as well as opposing counsel and his or her client, deserve a neutral evaluation of the issues, and someone who has experience, and when they say, when they give their opinion as to the value of the case or the liability issues, that you believe them. And that can change depending on the type of case that it is. If it's a personal injury case, we have a list of mediators in our firm that we go to, right? Because they're quick, they're efficient, they understand it. They've been on both sides of the table before. They know what cases are worth, or the range of what cases are worth. I, on the other hand, do a fair amount of securities litigation, FINRA arbitration. And I only made this mistake once, which is having a mediator who did not have any experience with securities litigation trying to mediate the dispute as if it was a slip and fall or car accident case. And that's just not going to work. So obviously the first thing you're looking for is, number one, a fair person, but number two, somebody who has life experience or preferably expertise in the area of law or the injury or the damage issue that's under consideration. So you're not spending your time educating the mediator, but instead you're spending the time engaging the other side about the pros and cons of the case, the weaknesses of their case, etc. You also want a mediator who's familiar with the jurisdiction. Who your judge is, if it's a case that's pending in court, matters, right? And that mediator may know something about that judge that you or opposing counsel doesn't know. Now, if you prepared properly for the mediation, that should not be the case, but we all know that there's certain judges that just aren't going to grant motions for summary judgment. And if you know that going in, that's a good fact for the plaintiff. That's not a good fact for the defendant, because it removes some of the leverage that the defendant would have with the ability to potentially dispose of the case on motion practice. Sometimes plaintiff's counsel might insist on using a particular mediator. And if that's what it takes to get the case into a mediation, and if that person is fair, and the defense attorney has done his homework on that person to ensure that he's fair, then do it. At the end of the day, that person can't make you or your client do anything that you're not already prepared to do. So after deciding who the mediator is, the usual next step is a phone call and this is how most mediators do it, and I think it's an efficient way to do it, where the mediator will spend no more than usually 15 minutes on the phone with counsel. And I'm using the example here of one plaintiff's counsel and one defense counsel, and that's the simple case. But you know, there's many cases where you have 3 or 4 defendants, and you may have just as many plaintiffs. So every case is different. But the point and the object of this initial joint conference call is to identify the issues, you know, confirm the date, confirm the location of the mediation, how much time is needed for the mediation. You know, I know sometimes, and it's a rare occasion when you have a multi-day mediation, that is definitely the exception to the rule in my opinion, and only when you have multiple defendants with conflicting positions and finger pointing, and you may have multiple plaintiffs in the same issue there, it can happen, you know, but I typically don't agree to a multiple day mediation if it's a simpler case of, you know, 1 or 2 parties on each side of the table. Because if lawyers have 2 days to mediate, believe me, they'll probably take 2 days to mediate. The other point of the initial conference call is to kind of set the ground rules for how, you know, who's going to be there. There needs to be a discussion and agreement amongst the counsel of, are parties going to be there? Obviously, the plaintiff should be there in person. The defendant should be there in person. Sometimes the insurer, depending on the case, should be there in person. Ideally, they should. At a minimum, they should be available via telephone if they're located out of town. Sometimes there might be coverage issues, insurance coverage issues, where that the carrier has advised the defendant that there's certain claims or components of the case that aren't entitled to indemnity under the policy. In those circumstances, you definitely should have a carrier representative at the mediation, and there should also be personal counsel present on behalf of the defendant to represent that defendant vis-a-vis the insurer, and they can address the coverage issues, which would leave the defense counsel to basically take on the plaintiff and the liability issues as to the underlying dispute. And the other thing that's usually discussed in the initial joint conference call is, are there going to be opening statements in the initial joint session? And we're going to get to the joint session in a little bit here. But as we all know, at least for those who have participated in the mediation, you spend most of your day in separate rooms. And you may see each other for a sandwich around the lunch hour. But the modern trend seems to be foregoing the opening statement in exchange for a simple get-together, an introduction of the parties, and the mediator thanking everybody for coming. But that's just a trend that I've seen. Sometimes cases need to have an opening statement. You know, sometimes the plaintiff needs to hear the defendant's position, and sometimes, you know, being a defense lawyer, we need to hear the plaintiff's position, and more importantly, the insurance carrier needs to hear the plaintiff's position so they know exactly where you're coming from, and that's your only opportunity in the course of the mediation to look eye to eye and speak directly to the person who's going to be making the decision, whether that be the plaintiff or the insurance carrier, or if there's no insurance involved at all, then the defendant. And looking at this next slide of issues to consider, I've already covered how much time should be covered, and I've covered who needs to attend. The other issue that may be discussed in this initial call is, will a settlement demand be made by the plaintiff prior to the mediation? And if so, when? And will a response be made by the defendants before the mediation? Again, there's no hard and fast rules. You know, every case is different. Sometimes it's certainly helpful to have a demand, and I think you know, you want to go into the mediation understanding what the initial demand is, recognizing that it's a demand. What you don't want to happen is you think the demand's going to be X, and then you get into the mediation, and the plaintiff's attorney makes a demand of X times 1,000, and everyone's looking at each other like, where did that come from? So I'm certainly a big fan of getting a demand on the table so we know what it is going in. Once you start getting into should an offer be made and then a counter demand, I think it's too much at that point, because you're beginning the mediation process before the mediation already begins. and we talked about other issues that the mediator should be aware of. So with that, I'm going to turn the next slide over to you, David, and to talk about the exchange and preparation of mediation submissions.
Sure, and picking up off what Andy said as it relates to the prepare and exchange of mediation submissions, you know, probably one of the key reasons why the opening statements are being utilized less and less is because I think a lot of folks are utilizing the exchange of mediation statements as a substitute, which is fine, but in order for that to be effective, folks have to really understand and dial in what the purpose of this exchange of position statements is. And one of the key questions to ask is, you know, who are we trying to persuade? Who are we trying to inform? And obviously, one of the reasons you're preparing it is for the benefit of the mediator, to educate them on the facts, to educate them on some of the law that you think is relevant. But certainly, you shouldn't lose sight of the fact when you're preparing this submission that you are setting the tone and the theme and the theories that will be utilized throughout the course of the mediation, and that's especially true if there's no opening statement. And so due care and concern should be utilized in prepping the mediation position statement, whether it be shared with the other parties or whether it's going to be a confidential exchange is sort of irrelevant as it relates to the amount of time you put into it. And one of the things that I think is important, and it's no different than your presentation eventually that would occur at trial, is you need to have these themes and theories dialed in a brief and succinct way so as to capture the reader's attention and tell a truthful and compelling persuasive story. And if you're doing those things, you've already started to build your case. You're starting to persuade the other side, the mediator, potentially the plaintiff, the defendant, whomever it is that is reviewing the statement. And I think we should presume that when these are prepared, they will be reviewed by everybody involved. And that's really what you're hoping for. That's what you want. And so setting the right theme and setting the right tone in that statement is important. And I always like to take the tack that mediation is not about attacking the other side, but providing them an analysis of your thought process succinctly and in a way that is not offensive but effective. And so you need to have that in mind, because ultimately the whole purpose of mediation is we're really trying to get this case resolved. And drawing lines in the sand, attacking the other party is not productive for your objective. Now, having said that, I will tell you, lawyers every day make that mistake, and I know Andy's been to mediations. I've been to plenty of mediations where this happens, and in fact, I think Andy and I have been to some cases together where that occurs, and lawyers are not only attacking to other sides, but offensive in some regards to their comments and statements or their submissions, and I think that's a big mistake as it relates to the setting the right tone in terms of mediation submissions. The other thing I'll say in addressing this mediation submission is, to the extent that parties elect to do a shared mediation position statement that would be shared not only with the mediator but all parties and all the lawyers, I always think it's a good idea, in addition to that, to draft the confidential mediation statement to the mediator that also sets the tone for what your expectations are. And this occurs sort of in a three-phase process, right? There's the 15-minute prep call that Andy just discussed. There's the mediation position statement that may be shared with all parties. And now you're going to have this confidential mediation position statement directed to the mediator, or maybe just a note or an email or something more informal that sort of takes it a step or two further as it relates to your settlement positions and your expectations about what needs to occur, what some of the obstacles might be to getting to a resolution that you perceive. And that way there aren't any questions about what your strategic objectives are behind the scenes. And that can be kept marked confidential. It will be kept confidential by the mediator, but it puts them on clear footing. When they show up at mediation, they have a clear understanding of where your camp is at in terms of settlement. And I think that's important And picking up on that particular point, the next slide talks about the consideration of ex parte heads-up calls to the mediator. And as this slide mentions, it's different than dealing with a judge or a magistrate on a claim where you're not supposed to and you cannot, under the ethical rules, have ex parte communications. When you have a private mediator involved, or even a court mediator for that matter, the process remains confidential, and you are permitted to have those ex parte calls with the neutral mediator to discuss your position. And I think the phone call following up on the opening call with folks and the mediation submissions, and now you have this sort of quick, brief third step in the process where you and the mediator touch base. And I typically like to do this in a day or two before the mediation. I'll leave a message with the mediator, usually during the day. Oftentimes, good mediators are busy throughout the day in mediations, but as they're leaving their mediation or traveling home, they'll oftentimes return those phone calls. And they'll do so, they'll call you in the evening on your phone. You can spend 5 to 10 minutes on the phone with them, talking sort of candidly about both your submission, the expectations, and what you're hoping to accomplish. And I think it sets the stage for the following day or the following 2 days when you arrive. I think folks you'll feel, if you're utilizing this strategy, you will feel like you were on the same page with the mediator before you show up into the room. And that's important in terms of getting productivity right away at the mediation, rather than spending the first few hours setting the tone, setting expectations, and educating. And then the next step really, after you have these submissions done, as a lawyer, it's time to get down to the nuts and bolts of the preparation. And the preparation is always key, no matter what we're doing, of course. But as it relates to mediation, it's no different. And knowing the strengths and weaknesses of your case and being able to talk about them intelligently and off the cuff, without notes, and without having to give it much thought, is important. And the only way to do that is you have to go through these points. You have to outline the strengths and weaknesses and jot them down, the reasons why or why not. And if there's legal support that's involved, make sure that you know it. And then you got to practice it, right? So understanding both the strengths and weaknesses and being able to talk about them is important. And also being able to talk about hurdles, right? Knowing the law, if there's damage caps in play, for example, that affect the damages that may be recoverable, that's something that you need to not only be able to mention, but speak about intelligently and discuss the law. If there's recent developments in case law, that's important, and that requires you to spend some time updating your research. And I think a lot of times we take our research, we take the caps, our knowledge about caps that we've learned over the years or in briefs, and the one thing that we fail to do sometimes, and I see this happen a lot, is that folks fail to update the research. They fail to take a second look to make sure that what they believe to be true is actually still the law. And there's nothing worse when you're at the mediation than presenting your position on damages or the recoverability of certain damages or the application of caps, and you present that in front of your client in a confident way, and it no sooner than comes back to you and you realize that that's not really the most recent holdings, that's not reflected in the most recent rulings, or you're just plain wrong. And it really reduces the effectiveness of your presentation. It reduces the effectiveness of the themes that you're presenting, and it can be very counterproductive to mediation. So all of those things, understanding the law in preparation is important. And down here at the bottom, preparing your talking points outline, and practicing your talking points is important. A lot of people overlook the practice part of this, right? You get all done with your prep, you know all the law, you've done the research, you now have sort of a thumbnail sketch of the outline of the relevant points, but you ought to run through it in your office, dry run, and make sure that what you're discussing, say it out loud, and that it makes sense. And when you hear yourself say it out loud, that it's, number one, believable, and two, that it makes good common practical sense in terms of the statements you're making. Because if it doesn't make sense to you, and when you hear it, it doesn't sound very good, your gut reaction is probably right. And then the final item on preparation is, and Andy mentioned this, is the coverage issues. If there are coverage issues, a lot of folks, I find, don't take them seriously, and those are things that should be paid attention to, especially if you are on the side of having coverage limitations, because it does impact the analysis significantly, and oftentimes coverage issues aren't fleshed out until the day of mediation, and if you're not prepared to deal with them and you haven't given them adequate consideration, it will be a barrier to further settlement talks, because without question, if they haven't been addressed before, folks have placed a value on the case as a result of consideration of coverage issues, either positively or negatively. And not considering those in advance of mediation, and potentially even addressing them in a similar manner to how you're addressing the mediation, which would be, right, the preparation of a statement to the insurance carrier or its attorney, and the phone call to the insurance carrier or their attorney to address these coverage issues in advance of mediation, so that the expectations are on the table and everybody is under the same understanding about what we're trying to accomplish as it relates to settlement of the overall dispute, and in this instance, resolution of a coverage issue that will impact resolution of the case as a whole. And so with that, I'm going to throw it back to Andy as it relates to further mediation preparation.
Thank you, Dave. And we have a couple of questions that I'm going to read, because I think only I'm seeing the question, and that way everyone will understand the answer. The question is, assume that you know of facts that your opponent does not know or has not yet discovered that you believe will result in a trial verdict in your favor. Also assume that if your opponent knows these facts before trial, he or she can adequately prepare for them at trial. Should you disclose these facts at mediation, thus letting your opponent know of them, and giving him or her the opportunity to prepare to rebut them at trial, or do you keep them out of mediation in the hope that their use at trial might decide the case? That's a great question, and it's a real issue that I encounter a lot, and I think a lot of you on the phone do as well. I'll give you a lawyer answer, and that answer is it depends. If you're being offered a fair amount of compensation to resolve the case, then you should resolve the case. But if you believe that these facts greatly increase the value of the case, then you have to ask yourself, is it too soon to go to mediation? Or should you disclose those facts at the mediation on the hopes that whatever they're offering you, they're going to increase the offer? And we'll talk about, don't be afraid to walk out of a mediation either. I mean, I've been to many cases. Nobody wants to have a multi-day mediation, or you start the mediation on one day, and then you have a reconvened session maybe 6 months later. That's not the norm. But I will tell you, when it comes to facts, if the other attorney is doing his or her job, they're probably going to discover what those facts are anyway. So my gut would be, if you're trying to get the case resolved and those facts help your case, let them know of them, because they're going to find out at some point in time, and if what you're trying to do is resolve the case sooner than later, and it can help you do that, then why not do that?
I agree with you, Andy, on that point, and I'll just add to this. I have a very simplistic view. I like this question, number one, by the way, and I don't know who asked it, but I think it's a good question, and it's an interesting one. But I have a very simplistic view on these issues, and that is the facts are the facts, and they can't be changed, in my opinion, and they will not be changed. And while there is the ability to try and counter some of these things, if it's one of those things that is a simple, straightforward fact issue, I'm always in favor of putting it on the table for two reasons, and they're simple. They're also simple reasons. The first is that the objective here is ultimately we as lawyers file these cases to get the dispute resolved, and holding things back that are beneficial or maybe not beneficial, as the case may be, it depends on your position, isn't productive to that particular course of action. And so unless your objective is to move forward and try every case that you have and put your fate in someone else's hands as it relates to the ultimate judgment or verdict, then I suppose that's a good idea. But our presentation, and I think there was a slide earlier, one of the tremendous benefits of mediation is that you hold the keys to your own destiny. And if you don't utilize the facts that are available to you in their entirety to provide leverage and resolve these disputes, then you're giving up the control that you have to use those leverage plays to your benefit. So I'm a guy, I can answer that question simply and straightforwardly. I would use those facts to my benefit, and I would disclose them, knowing full well that the facts are the facts. It is what it is, and we're still going to be left with this decision-making tree, whether it be a trial or mediation, and I want to get there sooner than later.
And to add to David's point, at a minimum, you should disclose those to the mediator. That might be one of those points that you would put in your confidential submission, or it may be at the mediation itself where you say, hey, they don't know this, but this is how this person is going to testify, or I have a witness, or this is a document that I know they have that they didn't produce. The only exception I can think of is if your mediation is a week or 2 weeks before trial, and you think it's that good, and you're willing to roll the dice, and more importantly, your client is willing to roll the dice based on their highest offer, as long as your client agrees with that course of action, then I can see that why you'd want to wait 2 more weeks to disclose it at trial to maximize the value of the case.
Now, there would be one exception I can think of, Andy, and we'll probably have to move on to get through this presentation, but I'll make it quick, and that is, I dealt with this once on a service-related issue in Ohio, whereby my clients were not properly served, and once trial would commence without service, their claim could not be voluntarily dismissed, and it would result in judgment for my clients. And I will freely admit that in this instance, I made a mistake, and so I'll use it for your educational benefit here. This was years ago, but I disclosed a service issue to the mediator, and although it was a breach of the confidentiality, the mediator mentioned to the other lawyer that he should look at the procedural issues in the case. He didn't necessarily, and I don't know exactly what his words were, but he did not tell them about the service issue, but he mentioned in passing that he should take another look at the pleadings and the procedural issues to make sure he was protected. And the lawyer did that and served my clients, just before the limitations period for service had run. And so I would say that's an example that I guess runs counter to my earlier point. It's a little different because it's a legal issue, but that's the one instance. And I don't know what this question pertains to, but if it's something along those lines, obviously you can see the pitfall there. And so I think it does require some caution, but that's the only caveat I have.
Another quick question, and then we'll get back to the slides, are what are your thoughts generally, given your experience, as to the trial judge conducting a pre-trial settlement conference? My answer there is I don't think we have a choice when it comes to the final pre-trial. If the question is the trial judge conducting a mediation, I would say I would not be in favor of that. But we all know from practicing civil law that judges conduct a final pretrial, and at that final pretrial, there's usually discussions about settlement and what the last demand was, or if there was a demand, what the offer was. It usually doesn't get much more detailed than that, and unless it's in federal court, it's not going to last more than a half hour to an hour. So those are court ordered. You don't really have a choice, you pretty much need to do it to comply with the judge and keep him or her happy. Back to the mediation.
And I would say, when you're in those pretrial conferences, those settlement conferences, the key is to show reasonableness. No matter if the judge is going to conduct it and you don't have a choice, then you have to stay focused on your level of reasonableness, and you want to make sure that you're the reasonable party in that, such that this judge is going to make some decision making on the case, and you want him to have the view that you and your clients are reasonable.
Correct. So mediation preparation, we've talked about the submissions. With regard to the mediator, what you want to accomplish is getting the mediator the relevant summary, the relevant documents, exhibits, attach those to your position statement. What you want to do is maximize the amount of time at the mediation to actually negotiate with the other side, as opposed to the mediator learning all these issues. If it's a good mediator, they should already know all the factual issues and a good understanding of the legal issues before the mediation even begins. But in order for that to happen, you as the attorney have to do your job and provide that information to the mediator. For the joint session, every now and then I've seen opposing counsel use video and use PowerPoints, and that's great. And it can be very effective, especially in complex cases. You certainly don't want to take it for granted, and you probably want to have that discussion with opposing counsel and the mediator in that initial phone call to make sure that you're both on the same page, so that nobody's getting outproduced at the opening session in front of their client. This is a big issue for us, right? I mean, on the defense side, for all the plaintiffs' lawyers that are out there, we need all the facts. We need, if it's a personal injury case, the medical records. We need to know, are there liens? Are there child support liens? Right? All the information you can provide to us in advance of the mediation is necessary for us to then submit a report to the carrier in enough time for them to put up a number, if it's appropriate, as to what the case is worth. So keep in mind that, while it's easy maybe if you're the plaintiff to get your client there in 30 days, it usually takes us 60 or 90 to get our hands on all the information we need, and from you, then to us, and then to the carrier, and then to them to get back to us as to what they're prepared to do. We talked about role of defense counsel versus role of coverage counsel. When it comes to authority, every client's different, and I always get a kick out of this. Sometimes clients will just say, we're not going to tell you. We'll just call us when you tell us what their last demand is, and then we'll respond. And that's fine. I mean, the client's the client, and that's what they want to do, then so be it. In other cases, they may say, you've got up to X, whatever X is, right? So it's a case-by-case basis.
As it relates to, yep, go ahead.
No, go ahead. I'm on your slide.
Yep, okay. As it relates to the opening session and the stages of mediation, we've touched on this a little bit, but I think I can't overstate the importance of the opening session. And, as Andy mentioned and as I mentioned earlier, a lot of times it's no longer an opening statement. It's more of a meet and greet. And it's important that in that meet and greet, if you're defense counsel, you set an appropriate tone. You've already made your mediation submission. And so the purpose of the meet and greet is to meet these people in person, to shake their hands, to let them know that you're there for the right reasons. And for example, if it's a traumatic injury type claim, thank you for being here, and I'm very sorry for the circumstances that you're in. We hope very much that we can make some progress today in resolving the claims, right? That's really all that need be said, but it is important that you set the right tone when you appear in the mediation, and it's got to be the right tone for the case. That opening line obviously is not necessarily relevant to a commercial dispute or something else. It may be, but to make sure that in that opening session in the meet and greet that you set the right tone. And if you're the plaintiff, of course, and your client, to make sure that those folks are, and you remind them as lawyers to be friendly, to be cooperative, not to set an aggressive or hateful tone towards an insurance representative, because those folks have to remember, especially in civil claims, that these cases are about money, and making defendants upset or creating sort of a hostile area, even though you feel that you've been wronged, you feel that you've been harmed. Typically it's not the insurance carrier or the adjuster that did the wrong to you, and they're trying to make it right, and your folks need to understand that they're here to try and do the right thing, and hopefully they will. So I think it's important, and I've been on that side of the fence. I've handled plaintiffs' claims, many of them, and also the defense side, and I think the right tone and reminding your clients to set the right tone is extremely important. And then obviously all your statements in mediation are confidential, making sure the right decision makers are there. If you are going to do an opening statement, if you're the plaintiff, I recommend running through some key points about injuries and facts and damages as a highlight, but I wouldn't dwell on them. And I think you get back to the focus of we're here with an understanding that we're trying to resolve these claims without expensive, protracted litigation, and we hope we can do that. That's a nice conclusion for your plaintiff's statement. For the defense side, typically, unless you feel that it's necessary that people hear you, you've already made your submission statement, and I usually recommend listening to the plaintiff and responding with, we are here, we've assessed your case, 3 key points, whatever you've identified as the highlight, and, we're here ready and willing to address these issues and hopefully reach some sort of compromise resolution that everybody can live with and reach a resolution to these claims. That's enough. And say it in a respectful way and move on. I think that's enough because you have to remember that the mediation is all about a compromise in claims, although we all are going in there with the perspective of doing the best for our clients. The reality is it has to be a compromise, and I think it's important to set that tone. And to the extent that you need to have more detailed discussions, I always recommend doing that in a breakout session. And, as we know nowadays in mediation, most of the day is spent in the breakout session. And so the next slide, I think we just passed through. I've already covered almost all of these issues and the efficiency and effectiveness of using the opening session. And so we can skip through that. And this is probably my favorite cartoon of the bunch that we have. Don't flinch, he's totally bluffing. And this is intended to be humorous, but I think the one thing I'll say, and this is just my personal opinion, bluffing at mediation is not, especially if you're early in the case, is not always a good strategy, and typically it's not. I don't play that game. I don't think Andy does either, and I just think it's counterproductive because if your bluff is called, whether you're a plaintiff or a defendant, you now have to live with that for the remainder of the case. And, I think the perception from the other side is that whatever it is you're saying from then on out is not the truth, or it's a misstatement of certain things for the benefit of your client or the benefit of your claim. And I think that sets the wrong tone, and it's the wrong way to handle your mediation. But the cartoon is nonetheless humorous.
So we've got about 10 minutes to go, 9 minutes, so I want to get through some of these breakout session issues and then get to mediators' tools. So as David said, most of the time in mediation is spent in separate rooms where the mediator is going back and forth, and that's when you really get the value of a mediation, that neutral person who can look you in the eye, who can look your client in the eye and say, I know you believe that. I know you believe that a judge or jury may conclude that, but you also have to recognize the risk that they don't. And sometimes we can't get through to our own clients. Let's face it, right? Whether you're a plaintiff's attorney or a defense attorney, so it's sometimes needed to have the mediator make those statements to each of our parties. And what I can tell you about breakout sessions is, you should have a committed mediator. Good mediations usually last a day, and you need to let that process play out. And although you think that you might have the mediation that ends before noon, and you can get your tea time at 1:30, that's only happened to me once in 25 years, which is why I schedule my tea times for 2:30 or 4, more likely. Just kidding on that one. But you got to let the process play out because usually for the plaintiffs, this is their day in court. If 90% of cases don't make it to the courtroom, then where do they go, right? They either get dismissed or they're settled or they're resolved in mediation. So it's important to respect the process and to have those individuals feel like they were heard and they had their opportunity in court, so to speak, even though it's not court, to state their case. You know, if it's not going to settle and you just get the sense that you're miles apart, you've got to be careful about, you know, lowering your demand if you really feel that you're going too low. And to the same token, you've got to be real careful about offering money that it's not worth the value based on the value of the case. So, you know, there's a bullet point there. Don't create settlement floors or ceilings that you're going to regret. And what I mean by that is, if you get the sense that it's not going to get done for whatever reason, too early in the case, more discovery is needed, just can't get through to one side, or you might have multiple parties involved and the target parties just isn't anteing up as much as they can, don't spend money that doesn't need to be spent, and don't lower your demand just because someone else hasn't taken the process seriously. You know, when all else fails, oftentimes I've pulled out opposing counsel to have a polite professional discussion to say, look, we're here to try to get this done. You know, what can we do to bring these parties together? There's nothing wrong with that. I mean, we both have the same goal. We've agreed to the mediation to try to get the case resolved, and that's what the objective is. But in the end, if it's not going to get resolved, there's nothing preventing you from leaving and walking out the door. I want to go a couple of slides ahead, David, to tools of the mediator. You know, but before I do that, I'm going to talk about, you know, sometimes there might be a need for a structured settlement. You know, they can be very helpful in resolving cases sometimes, which is basically to purchase a lump sum of money, paying periodic payments over the future, in other words, an annuity. In the right case, they can be, you know, invaluable in trying to bring about a resolution. And sometimes in those rare cases, the dispute is one of two experts who are fighting with one another, and it may be over the lawyers' heads, and it's sometimes best to get both of the experts in a room, and counsel can let them articulate their respective positions, and I've been part of that process before, where it's brought closure to the case. David, speak real quickly on jury verdict research and venue and life care plans, and then we'll end on the mediator's tools.
Yeah. Sure, and I'll get through these quick. The key to the jury verdict research is you actually have to do it, and it has to be relevant to your issues. If you do it, it is always useful, especially the bigger the case, the more useful it is. Smaller cases, I find it to be less relevant, but certainly if you have a big case, do the research and make sure that it's related to your issues. On the venue, you know, knowing opposing counsel and the judge is important. But I think if you're going to speak to trying a case and what the probable result will be, you better know what a dollar is worth in that particular jurisdiction. Meaning, you know who your jurors are going to be, their education level, the jobs, the political climate, all of the things that could be relevant to those folks' decision making and analysis of your case, because I do think it is relevant. Life care plans, of course. If you have future medical care involved in a catastrophic injury claim, this is an absolutely essential piece to your mediation. You cannot negotiate a future care plan at mediation without having a legitimate life care plan that is complete and focused on the medical issues that are at stake. So, and frankly, that needs to be, you know, there's talk about how the costs are placed in there, but typically that needs to be reduced to present value such that folks can really get a number of what today's dollars are going to cost for future medical care. So that's relevant. And back to you, Andy.
Thank you, David. We got two slides and one quick question, and the question is, please give an example or two of an ex parte communication with the mediator. You know, the one that comes to mind for me is coverage issues, right? So I'll pick up the phone and talk to the mediator and say, hey, Mr. Mediator, you know, coming to the mediation will be me, my client, but there's also some coverage issues which I cannot speak to because that's not my role. So you're also going to have a representative from the carrier. There may be an attorney representing the carrier on that issue. So that's an example of bringing that issue to the mediator's attention so that he or she's not surprised when 7 people walk in representing the defense side. Okay, mediator's tools, risks. You know, how much do you tell the mediator versus not tell? It's a case-by-case basis. You know, I would say be careful, right? Because the mediator's job is to get the case resolved, and if you go in there and say, hey, I've got X in authority, he's going to use it. I think you've got to be smart about, you know, disclosing your settlement authority. We've already talked about when to use facts and not to use facts. Bracketing is a good methodology to use when you're not getting anywhere with offers and demands, and basically what that means is, let's say the demand is $1 million, the offer is $100,000, there's a gap of $900,000, and you're not getting anywhere other than, you know, we'll go to $110,000, and then they go to $990,000 or $890,000. Basically, bracketing says we'll go to $250,000 if you go to $500,000, and it can be in a case that is going to settle. Once the bracket's agreed to, you pretty much know from what the midpoint of the bracket is, the range. It's not always going to be the midpoint of that bracket of what the case potentially could settle for. Mediator's number is usually a method of last resort when the bracketing doesn't work, the negotiation doesn't work, going outside, talking to opposing counsel doesn't work. With a mediator, does a fair, honest, neutral evaluation after listening to all the parties, all understanding the issues, and says, I'm going to make a number, and if both sides accept it, it gets the case done. But if only one accepts it and the other doesn't, it won't get it done. And the good thing about the process is there's no harm in doing it, you know, so that using that $1 million demand and my $100,000 offer, the mediator's number might be $275,000, right? And usually there's a deadline to respond to it. If both parties accept it, which is usually within 24 hours after the mediation, the case is done. If one of the parties doesn't accept it, then you're still at the same bargaining position you were. Plaintiff is still at $1 million, and you, the defendant, are still at $100,000. It's a good way, as a method of last resort, to get it done. Finally, settlement documents. Do not leave the mediation without having, at a minimum, a term sheet, you know, summarizing the relevant terms of the agreement, which obviously include the amount of money, how much time to pay the money. All the non-monetary things need to be discussed so there's no surprises. Is there going to be confidentiality? If so, what are the terms? Who's going to pick up the mediator's costs and expenses? Each side to pay their own attorney's fees. The timing of the filing of the dismissal entry with prejudice. Never leave the mediation without the signed term sheet. And quite frankly, lately, you know, I've been going into mediations with the settlement agreement and release already drafted, and I can make whatever edits I need to make at the mediation, you know, and to just forego that extra delay of time from the time you do the term sheet to the settlement agreement, because all of a sudden people's recollections as to what they agreed to differ even within 24 hours after the mediation. Kim has asked me to, I'm going to open up for questions. I don't think there are any more, but the secret code, the word in honor of this year's Masters, is Tiger Woods. So for your CLE credit, and Kim, can you just please explain to everybody, I think they probably already know from the materials that they've received as to what they need to do to get their CLE credit, but I think you need to write at some point in time that the secret code is Tiger Woods, who I hope all of you know is the gentleman who won the 2019 Masters.
Yes, absolutely. When you receive your evaluation, that will be one of the questions.
And I don't think there are any questions. Kim, is there anything else we need to cover, or are we wrapped up?
No, I think this is great. Thank you so much, Andy and David, for providing such helpful information and sharing your insight. Thank you, everyone, for listening in today.